About this particular issue of Kamau Wanjiru, I came on board in the year 2016. And one of the issues that I found is that the matter had progressed, I think from 2014. Then I came in at around mid-2016. One of the issues that led to my coming on board was that Kamau's mother had alleged that council representing Triza, that is Mr. Ndego Home, had taken over their properties and mismanaged. And therefore, she suggested that he was a potential witness. So it was then agreed between myself, Mr. Ndegwa, and Honorable Andai, who was the presiding magistrate then, that I represent Mr. Ndegwa as well as Triza, and Mr. Ndegwa especially on the aspect of those properties that Kamau's mother was alleging as having been taken away. I recall that when Kamau's mother testified, I had an opportunity to cross-examine her, majorly on the aspect of those particular properties, and she conceded that a succession course had been concluded in Nakuru, and that the estate had been vested in Triza and her children. And one of the questions I asked her is whether she had preferred any appeal against that decision, and she confirmed that she had not. And therefore the aspect of properties was a chapter closed at that. Moving forward, we had various and several witnesses who also testified, and the key witnesses were the watchman, a lady called Jane Duta, and our client Triza. Triza had testified, and there was corroborative evidence that she had left the premises before Kamau died. And therefore, the only two persons other than Kamau that were present in that compound were the lady Jane Duta and the watchman. The two of them do confirm that Kamau actually jumped from the balcony. And therefore, as a result of intoxication, he could not manage the height, the fall, and therefore he succumbed. We had a witness who produced a toxicology report that showed that the kind of alcohol in Kamau's system was up to 21 tots of whiskey, and that the expert said was sufficient to kill him in itself. It was lethal, according to the expert's opinion. And therefore, intoxication together with the height and the fall definitely could have left him dead. All those issues put together, and the way Honorable now Justice Wendy Misheni maneuvered through the evidence and testimonies before the court, it is clear, even in her ruling, that this was an accident. It was a case of an accident, and a case of poor judgment out of intoxication, where Kamau made a very poor judgment, where he thought that he could jump from the balcony without remembering that he was actually intoxicated. That was the holding of the magistrate, and the magistrate noted, and the magistrate was very generous with her time. Every time a witness would complete testifying, she would ask, including other members of the plenary, parties who had just come to watch the matter proceed, he would ask them whether they had any questions to ask any witness. And the people would ask questions. And in her ruling, she noted that there are some people who had some funny interests in the matter that she also could not understand, but she left the matter there. But she also noted that some of those people who surround Kamau's mother may not very well help her to overcome this issue and especially come to closure of this issue. I wish to note that today I know that Kamau's daughter is of majority age, and she is now capable of commenting on her father's property. I have not heard her say anything. She is not complaining. The Kamau's widow is not complaining about their property. As far as I know, the estate, other than those properties that have been discovered to have been taken away from the estate truly and correctly vests in the rightful beneficiaries. And therefore, the kind of sentiments I have heard, having been made by Hannah, Kamau's mother, are quite dangerous. She's treading on dangerous grounds. If, for example, Kansondegwa decides to take on her, then she'll be in for another long one, which may not be very advisable for her. So it is my unsolicited advice that she quits that direction. As I conclude, is to say that the whole of this issue ought to come to an end. I have heard from our client Teresa that her children are now starting to ask very hard questions. They are wondering why this issue is on and off every other time. The family herself and her children truly need closure, and I know she will speak for herself and for her family, but that is what she has intimated to me. And therefore, as we move forward, I would hope and propose that this matter ends at that. There is no appeal to the ruling on the inquest. Nobody has appealed against that decision. And therefore, these sentiments we are reading in newspapers are an attempt to appeal decisions made by a court. The decision on the property, the decision on the inquest, attempting to appeal those two decisions in the media, in the newspapers, in the court of public opinion, which may not necessarily help anybody. So that's all I would say, and say that there is need for closure to this particular chapter.